Good morning and good afternoon, everyone. I would like to welcome everyone to today's webinar um, sponsored by the CTRJJ. That is a juvenile justice overview. We're going to be building off of the resource guide for mental health professionals working with youth in the juvenile justice system today, with a focus on providing an orientation to the juvenile justice system. I'd like to do just a brief introduction of myself. My name is Dr. Keith Cruz, and I am one of the co-directors for the Center for Trauma Recovery and Juvenile Justice. For those of you who may not be yet familiar with the center, the CTRJJ is a Category 2 technical training and technical assistance center that's affiliated with the National Child Traumatic Stress Network and is funded through the Substance Abuse and Mental Health Services Administration. As is reflected here, the mission of the CTRJJ is to support a comprehensive framework for developing, adopting, implementing, and sustaining evidence-based and trauma-informed services for youth who are either in or at risk for juvenile justice system involvement. We also, include families and caregivers as a critical, important part of our mission as well, and also supporting the development and the training and support for the staff who are providing these services to youth and families as well. A couple of housekeeping things about our webinar today. This webinar is being recorded, and everyone will receive a follow-up email from the CTRJJ when the recording of this webinar is available on the CTRJJ YouTube channel. We are in webinar format today, and throughout the presentation, if you would please use the QA function to submit any questions or comments. Carly will make sure to work through any of those responses as we go through the webinar today. At the end of the webinar, we will provide a slide that will allow any attendee to access an attendance certificate. There will be some instructions for how to access that at the end of our time today. Please note in advance, though, that this is not available, or is sanctioned, through the CTRJ to provide continuing education credits. But if you'd like a certificate of attendance for your own professional development, there will be information to access that certificate at the end of the webinar. And with that, I will turn this over to our colleague, Dr. Carly Bates, who is the primary author on this resource guide, and a faculty member through the CTRJJ, who will be leading us through our dialogue and discussion today. Carly.
Thank you so much, Dr. Cruz. Hi, everyone. Thank you so much for joining us today. For those who weren't on our first webinar, just a little about myself. I'm a clinical psychologist. I'm an associate professor at Purdue University Northwest and a clinical assistant professor at NYU. And I've worked for many, many years with youth and families who are impacted by the juvenile justice system, which is what I'm going to talk about today. Before coming to clinical psychology, I also was an attorney representing youth in juvenile delinquency and also child welfare cases. So I could talk for hours about the juvenile justice system, the intricacies of it, and that is what I'm hoping to lead us through today. So I like to start my talks with kind of grounding us in person-centered, thinking about the youth that we're actually all working for and with. So a lot of the work that many of us do is really intertwined, I think, with what this youth, Marcus, who was a youth who was formerly in detention, juvenile detention, is expressing. So I think by bringing this knowledge to the field, we're really hoping to give more tools to those who work with youth in the juvenile justice system, probation officers, judges, but also mental health professionals who are either working in the system or who want to be working in the system, but feel like they need more skills and tools and knowledge about the system to be able to do that. So we're really excited. This whole webinar series is grounded in our resource guide for mental health professionals specifically. And our guide was released last month, so we've gotten some positive feedback. We're really excited that people are starting to use it and that it's making a difference. So this guide really, the goal is to offer practical knowledge about the juvenile justice system, working within it, and things that are specific and relevant to mental health professionals. So we're always doing that with thinking about trauma-informed care and trauma-informed guidance. And the guide really highlights this intersection between mental health and juvenile justice involvement for youth. And we also hope by sharing initiatives and resources that are specific to the juvenile legal system, that this provides even more resources for you as you think about your journey in working with the system, working with youth and families who are involved in the system. And we've done our best to capture all of this in 8 modules and 4 appendices. Within each module, we do have initiatives and resources and further reading and videos and things like that. And then we have a lot of that listed at the end in our last appendix. So there's a lot to cover in this resource. And so our webinars, the series of webinars, is really designed to break each of these down and focus more specifically on these certain pieces. So today, what I'm going to do is talk about these first 2 modules. So I'm going to really focus on an overview of the juvenile justice system and what it looks like for youth who might be navigating this very, very complicated and very, very complex system. So this guide was really designed specifically for mental health providers. And we felt really strongly that knowledge about the juvenile justice system is crucial for working with youth and families who are even just at risk of involvement in the system. Because a lot of the topics that kids might be bringing up when they're working with their mental health providers are about things that they're encountering in the system. And so in order to really be able to work effectively with this population, it's really important to have that foundational knowledge. So that's what we're hoping to do with these 2 modules and today. So this is obviously a large topic that I have taken on today in a little less than 60 minutes. The system is incredibly complicated and incredibly confusing. And even for those of us, I've worked in the system for many years, and it's still very complicated and confusing. But I'm hoping to demystify that a little bit today. I will say, I'll say this probably a couple times today, that every jurisdiction is very, very different. So in our guide and in our talk today through the system, I'm focusing more generally on some of the common components across different jurisdictions. But your local jurisdiction is the place, is the resource, right, for finding out more specifically about how things work in your system. So let's step back for a moment, again, sort of ground us in what we're talking about today. So let's say you're meeting with your adolescent client. You're the mental health provider, you're meeting with your client, and he tells you he was recently arrested. You get naturally very concerned. You start asking a lot more questions. So he tells you he was arrested. He remembers there were handcuffs and police officers. He also remembers that he went to this really big building with barbed wires and lots of staff. Things seemed really secure and formal. And he met along the way with somebody who was asking him a lot of questions. She was asking him questions about school, his attendance, grades. She wanted to know a lot about his family, his prior history, and lots of other stuff that he can't quite remember. But she said she was a probation officer. So he tells you he's pretty sure he's now on probation, but he doesn't know what this means or what he's supposed to do or what the parameters are. So you ask more and more questions because you're trying to get to the bottom of this. And he eventually tells you, well, he thinks he has a lawyer. He remembers meeting with a woman. He has no idea what her name is, but she seemed really stressed and really rushed. He doesn't know how to contact her. Maybe mom does. He's not sure. And then he tells you he thinks he saw somebody who looked like a judge, who was in a big robe up on a tall, like higher than everyone else. And this judge said something about parole. So he might be on parole. And you're thinking, but wait, wasn't he on probation? Are these the same things? Sounds like he was in sort of a detention center, but now he's here in front of me. What is happening? What is going on? What is happening with this kid? Where is he in the system? So I'm going to break all of this down for you today. And I'd like to do that by using a case example. And for those of you who were on the first webinar, you'll recognize this youth, Jonah. So I'd like to return to Jonah. And I want to return to him for some consistency. I want us to really kind of focus in on his journey. So I'll share a little bit of the details that I shared on the first webinar about Jonah for a refresher for those of you who weren't there and new for those of you who were not. So let's imagine you're working with Jonah. Okay, so here's what we know initially. So he resides with his mom and his two siblings. He is he was arrested for assault and possession of a weapon. And he does have a history of having 3 prior arrests for similar charges. So he has had system contact previously. He reports that he has been using marijuana pretty frequently, every day, 3 to 4 times per day. This began pretty early, around age 11. He's failing most of his classes. He's not really attending school very consistently. This started a couple of years ago, but really in the last year has attendance has really tanked in school. His mom reports that he's been in a lot of fights in the community and also in his school setting. She suspects that perhaps he might be gang involved, but she's not 100% sure. And mom reports that the family does have some history of child welfare involvement. So Jonah has experienced a lot of trauma in his life. And back when he was younger, there was domestic violence in the home, and his father was arrested and in prison for that, was incarcerated for that series of domestic violence incidents. And so there was a child welfare case called in around that those events. And mom is seeking mental health services. So this is really all we know, right? But we do know from mom and from what Jonah reports that Jonah has been arrested. He's been arrested reportedly for assault and possession of a weapon. And here we are. So I'm going to have Jonah take us through the system so that I can highlight various points along the continuum and really talk through some of the things that some of the kids that you are working with or might be working with might be experiencing as they move through this continuum. So first, let's talk a little bit about types of cases that kids might be encountering or involved in when we're talking about the justice system. So the first type of case, and again, this varies, this is very jurisdiction dependent. So this is more general overview of the types of cases. So the first is what is often known as a delinquency case. So this is a youth who's charged with, the language for a delinquent act is they are charged with an act that would be a crime if that act were committed by an adult. And this is where we find Jonah. So this is where I'll be focusing today. These are the cases that are primarily heard in a juvenile or a family court. The minimum age for a youth being prosecuted in a juvenile case, a delinquency case, it varies by state. Last I checked, just under 60% of states in the US actually don't have a minimum age. And then in others, it ranges from around 6 to 12. And then the maximum age for juvenile court is, I believe, 17 in most states now. Some states it's 18, and I think Vermont actually it's now 19. So again, this varies by state, but on average, pretty much every state it's at least 17. But every state in the country has a mechanism for trying kids as adults outside of these juvenile court age ranges. So an adult case where a youth is tried in adult court, they are charged in an adult criminal court. In that adult case, right, in that criminal court case, they are subject to all the same procedures that an adult would be in that court, including sentencing and collateral consequences, right? So being convicted of a felony has a lot of collateral consequences for things like housing and welfare benefits. Those would also apply to a youth who was going through an adult court case. So every state has a mechanism for that, and it varies by state. So for example, in New York, at the age of 13, if a youth is charged with murder in the first degree, they can be charged and tried directly in adult court. So that's very local jurisdiction specific. And then another category of cases that I want to just mention, I'll not be going into much today, is something called a status offense. So a status offense is a case that is considered a non-criminal act and is a violation of the law only because the person being accused of it is a minor. So these are things like truancy, not going to school, running away from home, use of alcohol underage, and incorrigibility, which is from the statute, not my language, where a youth maybe is, from a parent's perspective, out of control. And in these cases, they're very different from a delinquency case or an adult criminal court case. In those cases, a prosecutor is filing charges against a youth. In status offense cases, typically, it's a parent who's filing a case against the youth. And in many places, these are referred to as PINS cases, so persons in need of supervision. In some places, they're referred to as CHINS cases, children in need of supervision. So they might be heard in the same court. They're typically heard in juvenile court, so they may be heard in the same court as a delinquency case, but they don't necessarily have the same options in terms of sentencing and things like that. However, youth who do come in on a status offense sometimes can then end up in the juvenile justice system, sort of penetrating further down the continuum. So I think there has been a lot of advocacy recently around status offense cases and trying to either reduce their use or eliminate them entirely, but many states and jurisdictions do still have that as a type of case that a youth might be involved in juvenile court. And then just briefly wanted to give you a sense of when we're talking about adult court versus juvenile court, many differences in what happens for a kid who is going through the adult court system versus the juvenile court system. And this is just a snapshot. There are many others. So there's definitely a greater focus on punishment in the adult court system, whereas in the juvenile court system, in general, right, typically there should be a greater focus on rehabilitation and services to support that youth and the family. In adult court, have an option for bail, which is not the case in juvenile court. So juveniles are not actually constitutionally entitled to bail. So, and I'm going to talk a little bit more about what that process looks like for kids in a moment when we get back to Jonah. But in juvenile court, when a youth is detained pending their case, there's no bailout option. It's actually entirely up to the judge whether to release that youth to the community while the case is pending, or to detain or keep that youth in detention while the case is pending. So that's one major difference. Another difference is the right to a jury trial. In adult court, we have a constitutional right to a trial by a jury of our peers. In juvenile court, with the exception of one or two states, there's no constitutional right to a jury trial. So most cases in juvenile court are heard from start to finish by one judge, as opposed to adult court where they might be heard by, a trial might be heard by a jury. And then the language differs. So in adult court, we're all familiar with guilt versus not guilty, right? This person at the end of the trial is found guilty or not guilty or pleads guilty. In juvenile court, we refer mostly to that as adjudicated or adjudicated delinquent. And then another major difference in terminology is sentence. In adult court, what we think about as a sentence is referred to as a disposition in juvenile court. So slight difference in terminology, but an important difference. And then in adult court, there are much longer sentences. So that sentencing, the options for sentencing, both at the community-based level, so things like probation, and then also at the corrections level where, a youth is in a correctional facility. Sentences in adult court are much longer. They could have life at the end, up to life at the end of their term, whereas in juvenile court, sentences are much shorter. So they range, from 6 months to 24 months, but much shorter than in adult court, significantly shorter. So the most common way that youth enter the juvenile justice system, youth like Jonah, is through an arrest by law enforcement. So in 2020, which is the most recent publicly available federal data that I could access, there were a little more than 400,000 youth that were arrested in the United States. And there has been definitely a downward trend in youth arrests since the 1990s. But important to note that not all kids who are arrested end up moving through the system. So police actually have the option to release youth. If they're arrested, they can still release them with no further action. So this is called different things in different places. For instance, in Illinois, this is called a statement adjustment. In some jurisdictions, the police could divert them to an alternative program or community service. They could also refer them to juvenile court, and then a youth might be diverted away from the court system before the case reaches the judge. There has definitely been a much greater emphasis on diversion away from the court system in recent years. So roughly 46% or so of cases that are referred to juvenile court are diverted and not formally prosecuted. And I wanted to also then just back up for a moment before we get back to Jonah's experience through the system and just take a look at the youth themselves. So who are the youth in the juvenile justice system? Who are the kids who are most impacted by the system? So we know that Black youth are disproportionately represented as compared to the general population. So you see here, this is again staying with 2020. Black youth represented 32% of juvenile arrests, but approximately 15% of the general population in that year. More males than females, which has always been the case, although female arrests have increased over the last few decades. And then, apologies, this should say 15 and under. You have the large subset of youth around age 15 and 16 in terms of age in the juvenile system. And beyond demographics, I think it's also important to note that youth in the system, many of the youth that I've worked with as both an attorney and also a psychologist in detention, are smart, creative, have really important pro-social goals, but their families and their communities are really struggling. Many live in under-resourced homes and communities where they don't necessarily have access to the things that they need. The communities that many of the youth in the juvenile justice system come from also have a lot of community violence. It tends to be the norm rather than the exception. Very high rates of trauma exposure and child welfare involvement. Some of the kids who are in the juvenile justice system may be concurrently involved also with the child welfare system. And significantly higher rates of mental health disorders versus community samples. So around 70% meet the diagnostic criteria for at least one psychiatric disorder, with the most common diagnoses being things like ADHD, conduct disorder, post-traumatic stress disorder, and cannabis use disorder. And also elevated rates of learning disorders and a lot of history of involvement in special education and diagnoses of intellectual disability as well. So bringing us back to Jonah, this is the complicated system that he is now finding himself navigating through, right, after having been arrested. And this represents a simplified version of the system. So this is a chart that we adapted from the Galt Center to really try to break this down more generally, to give you a sort of a visual snapshot of what this might look like for a youth who's going through the system. So we're going to use this chart and the various components as we look at Jonah's process through the system. So let's start with that initial arrest and what happens from there. So in Jonah's case, the police arrested Jonah for assault and possession of a weapon. So we're starting here with just the top of that chart that I just showed you with his arrest. So in this case, they did release Jonah, the police did release Jonah to his mom, but there is further action. So remember I said one of the options might be that a youth is released after being arrested with nothing further. So they don't have to go to court, it's done. In this case, he was arrested, he was released to his parent, but he was actually given a notice to appear in front of a judge in juvenile court. So we know that he's not at least being diverted between arrest and his notice to appear. So he goes home with his mom, and In between his release to his mom and when he has to then appear in court, in family court or juvenile court, he has an intake with a probation officer. And this is typical. This does not mean that he is on probation. So there's always a lot of confusion about that. And as I mentioned earlier, right, a kid might say, like, I met with the probation officer, I think I'm on probation. At this stage, unlikely. But oftentimes kids will meet with a probation officer who does an intake, who gathers a lot of information about the youth, and also typically meets with the caregiver, the parent. And the purpose usually of that is for them to gather information to first inform whether the case perhaps could be diverted at this stage. So probation officer is doing the intake, but it hasn't yet gone to court. A prosecutor hasn't yet filed formal charges. So is it possible for this case to be diverted and Jonah to perhaps be engaged with a community alternative, right? Or do community service or something else to satisfy the probation officer and the system and not have this formally processed. So part of that intake is to inform that process. And sometimes that intake is also used to inform the judge, if it does get to a judge, about whether this youth should be released pending the case or should be detained. So here he goes through that process with a probation officer. He has an intake. And here, although there are many off ramps for diversion before getting to court, because he has a history of arrests in the past for similar charges, he isn't deemed eligible for diversion. So the prosecutor decides to file a case and files a petition against Jonah, which includes formal charges. And one thing I did want to note is that when a youth is first arrested, they are arrested for certain charges, charges X, Y, Z. This doesn't necessarily mean that those are the same exact charges that they will be formally charged with if a prosecutor does file a petition. It is actually up to the prosecutor at that point to decide what to charge the youth with. So in this case, the prosecutor files formal charges, charges charges Jonah formally and officially in the court system with assault and possession of a weapon and several other lower level charges. And after the prosecutor files this petition, Jonah then goes to see the judge for what's called a first appearance or arraignment. In that first appearance, Jonah receives a court appointed attorney. All youth are entitled to counsel if they are indigent, right? Can't afford their own counsel. And so in this case, Jonah he gets a legal aid attorney. And now, in this first appearance with the judge, the judge's main task here is to determine whether Jonah should be paroled or remanded pending the resolution of the case. So this is another, I think, source of confusion that if a youth is paroled, this doesn't mean they're on parole here. So in this case, parole, the term parole means they're sent home, or if, like Jonah, they're already home, they stay home. So they're paroled home to their caregiver, and they can remain home while the case is moving through the court system. If the judge determines that the youth should be detained, then this would be called a remand. So one other difference between adult court and juvenile court is at this point, when the judge is making this decision in juvenile court, the judge's decision is based on many different factors that are even beyond the seriousness of the charge. The seriousness of the charge absolutely plays a role. But judges in family and juvenile court, when they're deciding whether to release a youth home or allow them to remain home, they're also looking at things like school attendance, level of supervision at home, grades, prior history, the parent or caregiver. Remember, there's that probation intake. So that parent or caregiver may have been interviewed, and what the parent or caregiver says about how the youth is doing and whether they're following rules at home. Those also all go into this decision that the judge is making here. Also, whether the youth may be engaging in other behaviors that the judge deems concerning. So here we know that Jonah is fighting a lot in the community. He's fighting a lot in school. He actually hasn't been attending school very consistently. He's following the rules at home. There is an appropriate level of supervision, but he also does have a prior history. So this is sort of a toss-up whether he would be remanded or paroled home. But because all of these different factors are at play and not just the seriousness of the charges, even a low-level charge could, in some cases, result in detention. There has been a lot of advocacy in recent years to try to reduce this likelihood and really reserve detention and remand for youth who have the most serious charges and are at highest risk. But at this stage, when the judge is making this decision, they're really trying to balance the youth, the best interests of the youth, but also looking at what is the likelihood that this youth might reoffend before the next court date, and what is the likelihood that this youth will return for the next court date. So those are two of the things that are sort of overarching what the judge is thinking about when they're thinking about whether to send a kid home or detain them. And that's different from adult court. In adult court, the judge isn't looking necessarily at school attendance and all of those other factors. The seriousness of the charge, I think, and history plays a much more central role or exclusive role. So in this case, we weren't really sure, right, whether Jonah was going to be paroled or remanded. But the defense attorney makes a really strong argument, and Jonah's mom makes a really strong argument and outlines all the things that she's going to be putting into place in the home to make sure that Jonah gets back for his next court date and to make sure that Jonah does not get into any trouble in between now and the next court date. And the judge is convinced. And so at this first appearance, the judge decides to parole Jonah home to his mom and sets a court date for 30 days from now, from the first appearance, for what's called fact-finding. And fact-finding is another term that is used in juvenile court that's different from adult court. That is essentially the trial. So when we're talking about fact-finding in juvenile court, that would be the trial if it was in adult court. So now let's move down to the second half of this image and talk about going from that arraignment, right? Now in between, Jonah goes home. So now we're about here, right before kind of fact-finding or any adjudication. So Jonah appears, he comes back. He doesn't get into any more trouble in between those 30 days. So he appears next for the fact-finding, and he hears from his lawyer that the prosecutor is offering a plea deal. So in this case, the prosecutor is saying, okay, if you plead guilty to assault in the third degree, we'll drop the weapon possession charge. In exchange, you have to agree to do 12 months of probation, right? Which is, he would still be in the community, still be living at home. So in this case, when this happens, it is ultimately the youth's decision, not their parents, whether to waive the right to a trial. So kids, just like adults, have a constitutional right to a trial or fact finding. They don't have a constitutional right to a jury trial, but they do have a right to a trial. So it is their decision in talking with their lawyer whether to waive that right, which is a really important right that we all have, whether to waive that right to a trial or fact finding. They can do that and choose to plead guilty. So this is an offer from the prosecutor here at this stage. The judge would still have to agree and sign off on that. So it's never 100% guaranteed, but more likely than not, usually if there's an offer and the youth accepts and pleads guilty, it usually moves, not always, but it usually moves in that direction. So in this case, if Jonah decides to plead guilty, he will have to admit to whatever charge he's pleading guilty to. So if he's pleading guilty to assault in the third degree, he is going to have to stand up in front of the judge, and he is going to have to tell the judge why he is guilty of that particular charge. And at that point, the judge has an opportunity to ask him a series of questions. It's just directed to him, not his attorney, that Jonah does have to answer. And the judge has to be satisfied that he is pleading guilty voluntarily and knowingly, that he is actually making this admission. And in that case, then there's a finding of delinquency. So here, Jonah receives this plea offer and he considers it. And instead of going to fact finding where there would be a trial, he waives his right to the fact finding and he does plead guilty to assault. So this now results in a finding of delinquency. So he's adjudicated delinquent. And now that there has been a finding, the next step is for the court to decide his disposition, right? So also known as a sentence in adult court. So at disposition, and here he is allowed to remain with his mom pending disposition. At disposition, there are a few different options that are available to the judge. And this again is very jurisdiction specific, but in general, the general categories sort of go from least severe to most severe. So among the least severe or restrictive, I should say, dispositions would be something called a conditional discharge. So this is where the judge sets certain conditions and a period of time that the youth has to follow those conditions for that period of time. If he does, case is closed, done. The next step up from that is something called probation. Probation is one of the most common dispositions in juvenile court. And when a youth is on probation, he has to meet with his probation officer. He has to meet with his probation officer and meet certain conditions that are set by the judge. And then at the end of the probation period, the case is done. If that probation period doesn't go well and he doesn't meet some of those or one of those conditions, then he could risk being back in front of the judge, at which point he might then get a new disposition, which could be and most likely would be a higher or more restrictive level of disposition. And that would be something akin to placement away from home. It could be a residential treatment facility or even with the Department of Corrections. So here the judge determines that he or she is okay with him remaining home pending disposition. So a date is set for a disposition hearing. And in the meantime, Jonah then meets again with a probation officer. Again, does not mean he's on probation yet. He meets again with a probation officer for another interview, and that probation officer generates a report and some recommendations for what they think the judge should do in terms of a disposition. He comes back for his disposition hearing, and at that dispositional hearing, court date, Jonah receives 12 months of probation. So probation, as I mentioned, is the most common dispositional outcome for juvenile court cases. So I wanted to just talk for a moment about what that might look like for Jonah. So here he's been given the disposition of a 12-month period of probation. So as I mentioned, there are multiple different conditions that a youth might have to follow during that period. So for him, he has to do weekly meetings with his probation officer in person at the probation officer's office. He has to maintain consistent school attendance. He has to attend school pretty much every day with no unexplained absences. Because he has a history of marijuana use, he has to also show negative drug tests periodically. He's also ordered to do individual therapy as well as family therapy with his mom. He has a 9 p.m. curfew that he has to abide by, and the probation officer will absolutely check to make sure that he is abiding by that. And he can't get into any more trouble. He cannot have any further arrests. And if he doesn't comply with one or more of these conditions during that 12-month period, then the probation officer has the discretion to file a violation of probation, which does then bring the case back in front of the judge for another pass through the process. And like I said before, that could possibly and often does result in a more restrictive disposition. So this is Jonah's shot, right? To continue to make sure he's complying with all of these conditions in his probation period. But unfortunately, the 4 words that defense attorneys never want to hear is your client is back, Jonah returns. So about 6 months into his probation disposition, he's rearrested for an assault after a fight in school. And because of his history with the court and the fact that he was already on probation, the police take him straight to a secure detention facility. So he is not released home to mom after being arrested like he was the last time. He is actually sent to a secure detention facility. And because of that, a hearing has to be held very quickly within 24 to 40 hours of his detention. And at that hearing, so that is done for him, there's a detention and probable cause hearing. So there, at that point, the judge is now only focused on, is there probable cause to believe that this youth committed a crime? So the prosecutor hasn't even filed usually any formal charges yet. So there's no petition, there's no prosecutor yet involved. He's just been detained via a police arrest. So the judge is determining here, is there probable cause to believe he committed a crime based on whatever evidence there is at the moment? And should he remain in detention pending the case? So here, the judge determines that yes, there is probable cause to believe he committed the crime. And unfortunately, because of his history and the fact that he was already on probation, he's still on probation for another case, the judge determines also that yes, he is going to remain in detention as the case proceeds. So just a note about detention. So most detention centers are, there are a couple of levels of detention. And again, very jurisdiction specific, but in general, you might find non-secure detention facilities, which are smaller, more like group home settings. And then you have secure detention facilities. So those are more like a jail setting where everything is locked, and there's often barbed wire on the facility and lots of staff, and youth can't usually move anywhere in the building without a staff member. So in this case, Jonah is actually sent to secure detention. So this means he won't be able to move anywhere without somebody with him, a staff member, and permission. He'll have calls and visits with his family restricted, and he won't be able to leave the facility at all for any reason except to go to court. While in detention, so bringing this back to mental health, right? While in detention, he may be receiving therapy, possibly have access to psychiatric services, medication, but this really varies very much by jurisdiction. And so each kid in different jurisdictions might have something look very different depending on where they are. But now, bringing it back to the court process for a moment, because he's in detention, in most jurisdictions, the case will now has to move more quickly than it did when he was out. So if you remember, in my last example, he had about 30 days he had to come back for fact finding. Now, sometimes, depending on the level of charges and the jurisdiction, the prosecutor might have to file formal charges within a few days of his detention, and the case moves much more rapidly. So here, the prosecutor files formal charges within 3 days, and then again, we go back to this first appearance with the judge. So now he gets his attorney, hopefully the same attorney as last time. Not always, but hopefully. And so now the judge makes, again, remember at that first appearance, the decision is parole or remand. And here, unfortunately for Jonah, he is remanded to detention. So he remains there pending the case. And now this time, again, looking at that second half of the chart, there is no plea deal. So the case goes to fact finding. So there is a trial that is held for the case. He goes to fact finding. He loses the fact finding. So he's found guilty. And so he is adjudicated delinquent. So now there's a finding of delinquency. The judge decides to keep him in detention until the dispositional hearing. So in this case, he remains in detention. But let's say the judge does have the option to parole back to home between this stage and then the disposition. So let's say that the judge did decide to parole him home. One thing I also wanted to note for mental health providers is that there is often very little to no continuity of care when a youth goes, especially when a youth goes from a detention setting back to the community or even to residential placement. So even if there's a clinician or a therapist that's seeing a youth for therapy in a detention setting, they might not even know sometimes that that youth is going to be released from the detention facility until they're just not there anymore. They just don't return to the facilities. A lot of times kids will go to court from detention and then they don't come back because the judge releases them. This poses a lot of challenges for continuity of mental health care. So there's often a really huge gap. So I think as community, for those who are community mental health providers, this is really important to know. So a kid might be getting therapy in detention, but then the minute they're released, oftentimes that ends. So now that there's a finding, as I mentioned, the next step is for the court to decide disposition again, right? And again, at disposition, judges are tasked with really balancing the best interests of the kid with the protection and safety of the community. So here, because of his court history, because of the fact that he violated his probation by being rearrested, the judge that he meets with a probation officer, and he also meets with the mental health service in the court system. So this doesn't mean that this isn't the therapist, this is more of an evaluation to give the judge even more information about what he or she should do for disposition. So the judge will receive reports from the probation officer and the mental health services in the court to help frame that decision around, okay, what should this disposition be? And because of what I just mentioned in terms of his history, he does at disposition receive 12 months in a residential facility. So he will be going straight from detention to an out of home placement. There's no in between going home first. Go straight there. And so over the course of those 12 months, toward the end of that sentence, one would hope that the facility that he goes to for that residential treatment, that placement, would be setting up what's called aftercare services. So aftercare services are meant for kids who are being released or discharged from a period of placement. And this could again include mental health services, drug testing, mandatory school attendance, and other conditions that feel very similar to probation. So sometimes kids get confused and think they're on probation. It's aftercare. It's still a part of their sentence. And they have to comply with all of that to be able to successfully complete that 12-month sentence. So this is something that we've included in our resource. Just wanted to sort of give you a snapshot of what this looks like and a quote from a youth just about the level of security, talking about some of those secure settings that I mentioned. So you'll see that there are, a significant number of kids in detention centers, and detention centers usually are pre-adjudication. So those are for kids who are going through that court process but haven't necessarily been found guilty of anything yet. Or sometimes kids who are serving shorter sentences. So this is really important to remember because in a detention facility, if a kid is in a detention center, more likely than not, they haven't been found guilty of anything yet. So I always like to remind people of that because that gets confused a lot. And then in long-term secure residential treatment, typically those are kids who have been adjudicated, who have received a disposition or sentence of out-of-home placement. So I just wanted to take a moment, since I talked a little bit about aftercare services. So toward the end of his sentence, as I mentioned, that the facility where he's at for that placement should ideally be setting up those aftercare services. So there is some continuity of care between being incarcerated and then going back to the community. We know that that period of time is critical. That reentry period, going from incarceration back to the community, is really critical. In a study that we did a couple of years ago, we found that youth who were being readmitted, returning to detention, if they were going to return, they typically do so within the first year after discharge. And so again, really, really critical time to be setting up mental health services in the community and other services in the community, not just mental health, to really support that youth and their family with the goal, of course, is that they don't come back and they don't get rearrested. Just a final note about community-based services. So in the past decade, there has been a greater focus on increasing community-based services for this population, but there's so much more that is needed, particularly in the area of prevention and also in the areas of alternatives to detention and incarceration. We know that youth do much better when they're served in community settings. And the rates of reoffense and rearrest and reincarceration for kids who are in more restrictive placements like correctional settings and detention, we know that their rates of recidivism are much higher than kids who are in the community. So just a plug that for community-based mental health providers, right, you can play a really important role in increasing that access for kids who have current or prior involvement with the system. So hopefully after this webinar, you feel at least a little bit more equipped to do that. There is a lot about the juvenile justice system that I obviously couldn't cover in this short period of time, but we hope that you'll take a look at the guide where we have a lot more information, a lot more resources and initiatives that can help. But hopefully this gives you a little bit more of that foundational information, so you feel more equipped to be working with this population. So just ending as I started with some closing words from a formerly incarcerated youth who is now an adult, right? Just highlighting how important a mental health provider can be in the life of an individual or a youth who's going through the juvenile justice system, how impactful they can be in that youth's journey. So special thanks to everyone listed here, for everyone who contributed to this resource that was many, many years in the making and also contributed to these webinars. And please do check out our next webinars. So on October 31st, we'll be talking more in depth about screening and assessment. So we'll be focusing on some of the most common screening and assessment measures that are used particularly in juvenile justice settings, and some of which may be unfamiliar to providers who are working in more community-based settings. Then on January 9th, we'll be talking specifically about mental health interventions. So again, some of the more commonly used interventions in these settings. And then in March, we'll be focusing almost entirely on tips and strategies for mental health providers. So we're really excited to continue this webinar series, and we hope that you will join us. And here is the QR code to connect with the CTRJJ. This is where you can also access our resource as well as many other resources. And I know we have a certificate slide as well. So to download a certificate of participation, here is the information for that.
Thank you so much, Carly. There was a couple of questions that had popped up in the chat, which I went and answered for you. But one that I think
Perfect.
that might require, uh, um, someone as opposed to my baby legal training, as opposed to someone with actual JD, just to make sure I'm referring to this correctly. The question came up around how when a youth is making an admission, right? Like that you mentioned in this case, Jonah, is how is consent determined and the ability to make that admission? And what I mentioned is that consent in juvenile court is kind of a tricky concept. It's really different than consenting for mental health services, for example. Like one of the whole reasons we have a juvenile court system is the understanding is that that yes, adolescents have particular rights and responsibilities that they have in participating in the process, but the law will recognize that adolescents are different. But I referenced that this is the process of allocution and that it is really the judge's responsibility to understand and be able to train to ask those questions around their understanding in a developmentally relevant way.
Yes,
And I also mentioned that there is the process of defense attorneys have an obligation to raise, if they are concerned about the adolescent's understanding, that they could raise the question of their adolescent's competence.
exactly.
That then would stop the proceeding. But anything else you want to mention about that?
No, that's exactly what I would say. I think that the defense attorney, right, can raise an issue of competence if they suspect that the youth maybe isn't competent to allocute or execute that allocution. And then it is also the judge, right, as they're it's part of the reason why they're asking those questions is to make sure that the youth fully understands. But I know there is a lot of research out there on that not necessarily being the case, right? Even for adults, I think the plea allocution, it's a very complicated process that comes with a lot of pressure because oftentimes you're facing, what might be a more serious charge if you don't plead guilty. So, but no, I think in terms of that competency question, certainly those are the two pieces that come into play.
Yeah. And Carly, and could you just slide back one slide to leave the
Yes.
QR code
Yeah. Yes.
is there as well? That would be great. And we're gonna have another comment. And thank you, Judge Howard. I think is raising the question is that or comment that it's pretty unclear whether kids truly understand what's
Mhm.
happening.
Yes.
And that's certainly been my experience as well in meeting with youth as like either a forensic evaluator or youth that I'm working with in treatment. What happens in court occurs so quickly, and even when youth are saying, "Yes, sir, I understand," etc., it's really challenging. And Carly,
Extremely.
do you want to comment on that?
No, I mean, just thank you for raising that. It is so challenging. I think this was an area that I never felt comfortable. It was just like, does this kid really understand? And then as the mental health provider after the fact, right, when you're talking with a kid who's pled guilty, it really does not seem like they understand both what they're pleading guilty to, but also the ramifications of that. Particularly when kids are in adult court, that gets really challenging, given that they're, facing all of those same collateral consequences that an adult would. And it just I would say from the defense attorney perspective, I can think of many situations where I did my best to explain, but you have so many cases and there's so much pressure to get through them that it just feels like it's not set up, right, in a way to really 100% ensure that the kids who are pleading guilty really understand and that also their families understand, right? So it's up to the youth ultimately, but the parent is a part of that process too. And
Yeah.
it's not set up that way. So I
And
appreciate that comment, Judge Howard. That is very true.
yeah, and I would also just kind of comment, and then I have a question for you, Carly, as well. But is when competence is raised, uh, through a statutory procedure within juvenile court, the proceeding has to stop
Yes.
until that
Got
competence question is
right.
addressed, and that would typically involve a separate evaluation by a trained mental health professional
Right.
who would be evaluating that. And but we're oftentimes seeing this in pretty extreme cases, in cases of extreme mental illness or intellectual disability where this might emerge.
Yeah.
But
To, to that point, I think, right, sometimes it's not raised because it would extend the time that that youth is involved in court. And I think I mentioned this, but I don't know if I highlighted it, but the process is much faster than in an adult court setting.
yes,
So you might have, a youth within 30 days is coming back for fact finding. If you raise a competency issue, right, that stops the process. And especially if you have a youth in detention, and now that youth is going to be lingering in detention for much, much longer. So I think that also complicates, right, whether that and when that's raised.
absolutely. And I think it's important for mental health professionals who now we're talking legal jargon here, right? A bit, but it is even if you're advocating for your client around some concerns about their understanding when they're in the middle of this process, please note that the frame that a lawyer will look at that is exactly what Carly mentioned, is there are collateral consequences of raising a competence question that can be really, really challenging. And can actually extend the time that the youth may actually be involved in the court much longer.
Yeah,
Um,
absolutely.
but Carly, could you address just one more quick question? Is the to mental health providers who may be working with a youth who is early in the process, right? How to help them clarify the difference between, being on probation or not on probation when before their adjudication.
Yeah, so I think having this knowledge, right, be able to sort of like know that if they're that early in the process, it's unlikely that they are on probation unless it's from some previous case. So being able to just to explain that there's a difference and that you might be meeting with a probation officer a few different times who's going to ask you a lot of questions, but this doesn't necessarily mean that that's your probation officer and that you're on probation. And I always, it is sometimes really challenging, but being able to have mental health providers also connect with the attorney is just so important, and it's so challenging in so many ways for lots of different reasons that we'll go into in future webinars. But that too, I think, can really help, right? Because at the end of the day, the mental health provider isn't the attorney, right? And they're not in the courtroom. They don't know exactly what's going on. But being able to get that information from the lawyer and encouraging the youth, if they know who the lawyer is and how to contact them and their family, to really get in touch with the lawyer to ask those questions to clarify, I think is also really, really important.
Yeah, that's great. And so I think we're at our hour here. And we've also posted in the chat the way for you to connect via email to the CTRJJ as well. Thank you, Dr. Bates, for sharing both your psychological and your law training with us today to give us a very quick snapshot and overview of the juvenile justice system. Thank you, everyone, for attending today as well. And stay tuned for future information about subsequent webinars connected up to this really amazing resource guide.